I've reviewed this matter and I wish to share with you my thoughts on same. What are the facts and what is the truth? The bill approved by the LRC and thereafter by the Cabinet did not contain the version of Section 34, which was eventually approved and passed by both the lower and upper houses. In other words, you will recall the House passed it in one form, went to the Senate, and at the Senate, on the floor of the Senate, without oversight by the LRC or of the Cabinet, an amended Section 34 was passed by opposition, independent, and government senators. The amendment to Section 34 in the Senate, unanimously approved there, changed the limitation on prosecution of certain offenses from 10 years from the date of charge to become 10 years from the date of commission of the offense. No one considered then, as some seem to suggest by innuendo now, that this change was in any way a nefarious ploy born of some ulterior motive. I make a point again. The amended Section 34, which placed a limitation of 10 years, not simply on what was approved in the House, that is from the date of charge, but placed a limitation from the date of commission of an offense. Passed in the Senate by all present and voting. What it meant then is that no prosecution could take place after 10 years of the commission of an offense or since the defendant first appeared in court. On August 6, as I say, the Honourable Minister of Justice tabled a note before the Cabinet which sought Cabinet's approval to proclaim the Act with effect from January 1st, 2013. The note also sought approval for early proclamation inter alia of Section 34 on the basis that it was necessary to, and I quote from the Cabinet note, facilitate a seamless operational transition and give authority for the recruitment and appointment of Masters of the High Court by the Judicial and Legal Service Commission in order that the Act may be operationalized on its effective date of January 1st, 2013, end of quote. At that meeting of the Cabinet, I specifically inquired of the Honourable Minister of Justice whether the Honourable Chief Justice and the DPP were consulted on these measures. The Honourable Minister of Justice drew my attention to paragraph 5 of the note, which stated that the Honourable Chief Justice had been consulted on a date for proclamation. He then confirmed to the Cabinet that he had the support and approval of both the Chief Justice and the DPP on this matter. The approval by the Cabinet of this piecemeal proclamation was therefore predicated upon and based on the assurance and understanding that the judiciary and the DPP were adequately consulted and fully supported the earlier implementation of this measure as a precursor to the rest of the Act that would come in force in January 2013. In accordance with established practice and procedure, a Cabinet minute was subsequently issued directly to the Chief Parliamentary Council for the preparation of the draft proclamation. This minute would have been forwarded by the Cabinet Secretariat to the Chief Parliamentary Council. This draft, prepared by the Chief Parliamentary Council, is then sent from the CPC to the Cabinet Secretariat for onward transmission to the Office of the President. I have spoken to the Chief Parliamentary Council, and he has informed me and confirmed that the Honourable Attorney General did not participate in this process because conventionally the Office of the CPC independently liaises with the Cabinet Secretariat and the Office of the President on such matters. I pause also to note that the Attorney General was out of the country during the period July 20th to August 4th. Soon after Section 34 was proclaimed, the DPP expressed concerns to the AG about the implications and consequences of same. The AG sought an immediate audience with me, and having examined the matter myself, I was satisfied that the consequences and far-reaching implications of this section was not consistent with government policy. A detailed press release was also subsequently issued by the DPP, outlining his concerns about the impact and consequences of Section 34. In the circumstances, I gave instructions immediately for the Parliament to be convened to consider repealing Section 34. I also summoned Cabinet to an emergency meeting to discuss the matter. The government therefore moved swiftly to successfully reverse the ill effects and unintended consequences of this Section 34. It is my respectful view that this demonstrates the bona fides of government in its quest to provide good governance. Following several days of inquiry and investigation, I contacted the Honorable Chief Justice to inform him about the apparent contradiction between his concern on the early proclamation and our understanding through the Cabinet provided by the Honourable Minister of Justice and our discussions with the Minister of Justice. I humbly requested a report on the issue. The Honourable Chief Justice provided a written report, and he also provided notes taken at a meeting held on July 24, 2012, with a specially appointed interministerial committee. On Wednesday, September 19, 2012, that is yesterday, I met with the Honourable Chief Justice and the DPP to discuss these issues. I am now satisfied that there was no prior adequate or proper consultation with either office holder on the early proclamation of Section 34. I am also satisfied that there was a legitimate expectation that on the part of the Chief Justice and the DPP that there would be no partial proclamation of the Act, as this assurance was given by the Minister of Justice at the said meeting of the Justice Sector Reform Committee held on July 24, 2012, and there was no subsequent meeting to that of July 24, 2012. Accordingly, it is implausible that they supported this measure for partial and early proclamation. The procedure in the Cabinet in our system is based on two very important constitutional principles, and they are as follows: individual ministerial responsibility to the Cabinet and collective responsibility of the Cabinet for decisions taken. All ministers have a sacred duty and responsibility to the Cabinet. In seeking to persuade the Cabinet to approve his or her note, a minister has a duty to present his case objectively and accurately, in the knowledge that the Cabinet will act on his or her assurances and representations. The Cabinet is entitled to rely and act upon the statements made. It influences, informs, and guides the deliberations of the Cabinet on the particular issue. The Cabinet, on August 9th, in reliance upon the assurances by the Honourable Minister of Justice regarding the support of the Honourable Chief Justice and the DPP for the measures contained in his note to Cabinet, approved the early proclamation of Section 34 and subsequent proclamation of the rest of the Act to be January 2nd, 2013.